state of Florida and Mr. Goodman of a fair trial. And not just with some accidental misstep, and not just once, but twice. And if I thought that Mr. Martin had the financial wherewithal to reimburse the state and to reimburse Mr. Goodman for the money that he's forced them to pay to reconvene a second trial, I do so, but it's clear that he doesn't. And it would be folly for me to try to extract that out of him. I agree with Mr. Johnson, too, that Mr. DeMartin doesn't owe anybody, and the court cannot consider his lack of remorse, his deciding not to apologize or to tell him or to say, no, I'm sorry. I can't aggravate a sentence for that. The law is clear on that. And but it is incongruous to hear counsel argue that he's remorseful, and there's zero evidence of that. There's no evidence of that. I can't consider remorse in reducing a sentence, and so I will exercise my discretion and not reduce what would ordinarily be an appropriate sentence because someone does show remorse. The law does permit the courts to reduce the sentence because someone is genuinely remorseful. And I've seen no evidence presented here in court of his remorse. So the bulk of the sentence is to a large variable in my sentence has to do with creating terms. I don't believe Mr. DeMartin ever will be a juror again. He's now over 70 and has the privilege of choosing not to be a juror. But frankly, I don't know if he decided to come down, if he ever is called to come down and subject himself to the jury selection process. I don't think he's selected. So I think the practical possibility of him being a juror is but general let those people held to come down and serve as a juror. How important it is to tell the truth, the uncomfortable truths about who you are and where you come from and your attitudes and your motivations are appropriately questioned so that lawyers, civil defense lawyers, prosecutors, criminal defense lawyers, civil litigants, criminal litigants, all can have a fair trial with known quantities of the citizens sitting in judgment on them, to ferret out hidden agendas, to ferret out subconscious prejudices or bias. And that is the foundation of our democracy. The right to a fair trial by disinterested men and women who are passing judgment on hugely important issues, not only in the lives of the litigants that come before them, but for the stability of our democracy. Honest. And I want potential jurors, all of our citizens, to know that when they come here, when we ask them questions, not only do we expect the truth, but we're entitled to it. And we got far less than that from Mr. DeMartin. And so it certainly brings me no joy to impose a sentence. But I think that it is incumbent upon me to have that courage to send that message. So Mr. DeMartin, having found you guilty of 2 counts of contempt of court, I'll impose the following sentence. As to count 1, I'm going to sentence you to 5 months and 29 days in the Palm Beach County Jail. The first 120 days shall be done in custody. balance of that sentence may be done via the in-house arrest program. I'm going to adjudicate you guilty of contempt of court. I'm going to impose mandatory minimum court costs. I'll do that with a separate order. As to count 2, I'm going to impose the identical sentence. I'm electing to have those 2 sentences run concurrently with each other as opposed to consecutively with each other. So the sum of your sentence for these 2 independent separate acts of contempt of court will be 5 months, 29 days, the first 120 days to be served in the Palm Beach County Jail with no in-house arrest. And that's if you're eligible for in-house arrest from the balance. I'm not guaranteeing that you're going to get in-house arrest for the balance. I expect to be eligible, but my expectation that will happen. That's only provided for that option. And the Palm Beach County Sheriff's Office has a protocol. They see about your eligibility, but I don't know anything about you that would preclude you from being eligible for in-house arrest. All right. And we'll need to get fingerprints and sign judgments, and I'll sign those with Mr. Johnson. He sees to it that the appropriate picture gets prepared across you and the judgment. Anything else?
Yeah, a few issues, Judge. Number 1, I want to ask about something you just said about the sentence. Obviously, 120 days in custody, would the court consider waiving house arrest fees for the final 60 days? Mr. DeMartin is not going to have the means to pay for that, so...
I think they've got a sliding scale. Don't make me your first stop on that request. I think you can probably work out something with the sheriff. If you can't, check with the state. You can send me an agreed order on that, which frequently that happens. If the sheriff doesn't relent and he doesn't have the means and the state doesn't agree, then certainly put it on my docket and I'll consider that the books.
Second request will be, we filed yesterday a motion for post-hearing trial or OR release, subsidious bond. Mr. Gershman filed that yesterday. I'd like to have that addressed now.
What is it you'd like me to do?
I'd like for you to release Mr. DeMartin OR pending appeal. I think obviously the issue here, Mr. DeMartin has no record. Mr. DeMartin has never been arrested, charged, convicted for any criminal offense. This is the first incident. He has no other open cases. The county court case, misdemeanor case, again, maximum sentence, which you've just imposed, is 5 months and 29 days. He's indigent, and I have an affidavit. He's actually been prior declared indigent for purposes of appeal, which we obviously will be undertaking. I'll file a notice of appeal this afternoon. And certainly there is this meritorious, non-frivolous issues for appeal that are on fairly debatable grounds and which will be made in good faith.
Have you listed those? I think the law requires, the rule requires you to list those other than just generically saying we have meritorious and non-frivolous issues. What are they?
Well, I think first of all, Judge, the court yesterday in making your ruling, number 1, issued basically said that there was reasonable doubt as to one of the counts, one of the elements of one of the counts. I think that's going to be a very big issue on appeal. Again, I think that the record, I'll just kind of parrot myself here, the record is absolutely nil of count 1 having any proof of Mr. DeMartin or any juror for that matter being sworn. So number 1, I think, as far as count 1 is concerned, there are certainly meritorious issues for appeal. As far as count 2, again, there is no evidence of intent or lack of evidence of intent. And again, zero evidence that the experiment and the things gained from the experiment anyway made their way into the jury room or into Mr. DeMartin's deliberations, which is really the violation of the rule, not doing the experiment. So I believe that there are meritorious appeals on both counts. In addition, we filed multiple pretrial motions, motions to dismiss, motions to, obviously get, rules to show cause, motions for evidence, lots of motions pre-trial, motions to disqualify the court, motions to disqualify the state, all of which I think you can at least say it's fairly debatable that there are appellate issues on. So, you know, and again, I just want to kind of note, because this case does come from the Goodman case, that the court, and the reason I asked for OR is because in that case, in the order, and I'm citing directly from the order in the Goodman case, that you granted bond on post-conviction, the court considers the defendant's finances in setting the bond requirements in addition to the factors listed in 903046. Again, which is, I'm sure it's just, you know, Mr. DeMartin has no ability to just flee the jurisdiction. Again, this is a, you know, a jail sentence that is, you know, that is not a 16-year sentence as you imposed for Mr. Goodman, having, you know, his actions having led to someone's untimely death. And so this is obviously not that situation. I can provide you the affidavit of indigent status if you like.
Yeah, file that. I'll find that Mr. DeMartin is indigent for purposes of appeal. And actually, the court makes that call that I adopted, particularly that and verified it.
I mean, he makes Social Security does not, you know, does not make a man nor, you know, nor books he's written.
All right, court's found that he qualifies, and so I'll find that he's indigent for purposes of appeal.
Okay. And as such, he wouldn't be able to afford a bond, which is, I think, my bigger point here. So OR status would really be the only way that he would be able to maintain his liberty while appealing what are, in my mind, fairly favorable grounds on appeal.
All right, thank you. Mr. Johnson, any argument on that?
Yes, briefly. I've got a couple of cases I want to provide the court.
Yes.
First, speaking of the Creighton versus State case 310 Southern 2nd, 381, and that's 4th District, 1975. One of the issues here, and I hate to be a stickler, but I'm going to be, there's been no appeal filed. And the Creighton stands for the proposition that it's not timely at this point to consider supersedious. Youngins versus State, which is the seminal Florida Supreme Court case, 90 Southern 2nd, 308. It's a 1956 case, talks about the considerations of the court. And the State is of the mind that this was not only fairly tried, but there's a wealth of evidence of the contemptuous act of Mr. DeMartin, and that it's not fairly debatable. The testimony and the evidence speaks for itself, and that the State does not believe that the supersedious is appropriate in this case.
Thank you very much. All right.
Just one more thing.
Yeah.
Number one, I think, I believe the court gave Mr. DeMartin credit for his time in custody, so I'd like to ask that the court give him the 2 days credit that he's entitled to from last night to that.
Oh, thank you.
Yeah, number one. Obviously.
Minus 2 days credit.
Yeah. The other issue, Judge, I'd like to raise is, you know, again, the appellate process is long. I don't know how quickly this will be litigated. I would be asking for the public defender to be appointed for purposes of appeal.
Let me go ahead and appoint the public defender for the purpose of appeal, and if you all decide to pick it up, you can file a stipulation for substitution.
But again, I think that, and just to kind of, I didn't disagree, obviously, with Mr. Johnson here on the merits of the appeal, but obviously Mr. DeMartin is being to stay in custody for the term of the appeal. If I'm correct, which again, I feel I'm correct, he will spend about 4 to 6 months in jail, you know, and then maybe get the case reversed, and that's irreparable harm that none of us can undertake that.
I'll find that no appeal has been filed. One, I'll find filed. Based upon what I've heard by way of argument, I don't find that there is a fairly debatable issue on count 2. Count 1, I do find that there's a fairly debatable issue. So as such, on count 1, I'll set bond is a superseding bond amount of $10,000. Count 2, I'll set bond at $9,000. All right. Other design judgments, together, other business.
Is that ruling not prejudice if I file an appellate?
No, well, yeah, I think
you're,
I'll leave it open, because I don't know what you might say, and, maybe you'll give rise to some fairly debatable, issue that you haven't heard to yet. But, I don't think it's a fairly debatable issue on account of but I am interested in the issue. My view is, I think that the jury being sworn versus not sworn is the jury, scenario channel. Certainly, I think that's a prerequisite for person, but I'm not so sure that's the law, and there is no law. And I don't mind the appellate court giving you that for a final point on that. I don't believe so, but I think it's a position. I think it's not purpose. I don't think you have that advantage here. So yeah, I'll leave it go. Without this. Oh, thank you so very much. We'll be in recess. Mr. Johnson, you can have the court for the judgments and all sign the change. Thank you so very much.